The Judicature Appellate Jurisdiction Amendment Act 2021 and the Judicature Parish Courts Amendment Act 2021 were both given the nod by the Senate on Friday. The two bills will grant the limited right of appeal to the prosecution in criminal proceedings in the Parish Court and the Supreme Court. Here's more in this report. Senator Kamina Johnson-Smith, who piloted the legislation, said the amendments will give victims a voice, noting that under the present law, the prosecution has no right of appeal against a verdict of acquittal in criminal proceedings.
So while we do address the matters of increased use of forensic, as we have continued to do, the establishment of the relevant labs, the database, the provision of training to our detectives and to all the technicians who are needed to ensure that the forensic lab operates well, our ability to grant greater mobility and capacity to our police force and our investigative forces, the rolling out of Jamaica Eye and the cameras, all of that is working on the side of apprehension and certainty of apprehension. But it's not the only aspect. So we have to deal with the different pieces of the puzzle. And this one is on the side of the justice system. And it is on the side of giving the victims a voice through the state. And as Senator Braham most correctly said in his closing words, certainly when we look at the society, when we ask of the society and we ask of the state, must it be that the state only has an obligation to the accused? Do we not have obligations as well to the rest of society and to the victims? The answer is certainly yes, Mr. President. We do owe it to our victims to ensure that where errors are made and that where new evidence presents itself and where there are administration of justice offenses, that the prosecution must have the right of appeal.
She explains that the legislation seeks to amend the law to grant the prosecution a right of appeal with the consent of the Director of Public Prosecutions, where there has been a verdict of acquittal in an administration of justice offense. But there are certain checks and balances.
The matter of the appeals on the administration of justice offenses, where once the Court of Appeal grants the leave of appeal for administration of justice, and sentencing then the Court of Appeal has 12 months to hear the appeal after the date the application was made. And then for points of law, it's 12 months after the date of the appeal is brought, the date that the appeal is brought. Then where the court orders a retrial from any of those applications being brought, that is those applications for leave, then the retrial must commence within 6 months from that date. On which the order for retrial was made. In the second part, for new and compelling evidence, then the time limit is where the Court of Appeal rules that the matter is to be retried. And then the trial court must fix a date no later than 2 months after the date of that order. And these are the timelines that are set out in the Act, and there is no express right to expand time, and there is no express right to prohibit the expansion of time.
It should be noted that the bills will amend the Legal Aid Act to allow legal aid to be available to a respondent in any criminal appeal. The definition of the prosecutor will be the Director of Public Prosecutions or any of the attorneys at law employed in that office or an attorney at law to whom the DPP has granted a fiat to prosecute the case, a clerk of the court, the Integrity Commission's Director of Corruptions Prosecutions, the Director General of the Major Organized Crime and Anti-Corruption Agency, MOCA, and a person who has initiated a private prosecution.
Those persons are all considered judicial officers for the purposes of this section. If you read the chapeau, it doesn't make them judicial officers at large. It is for the interpretation of this section. And what that does is not only allow them to appeal, but it also protects them under the administration of justice offenses. Those administration of justice offenses can be can include actions against judicial officers. So the intimidation of the clerk, intimidation of whoever is prosecuting, those are offenses as well that can affect the administration of justice, and therefore it was felt that they should benefit from that protection as well. And it doesn't apply across the entire Act.